For judgment, item number 1.
As a result, the appeal is allowed. Judgment and order dated 7/9/23 is quashed and set aside. Case is remanded back to the Learned First Appellate Court for decision on merit.
Deeply obliged,
Obliged.
Your Lordship.
For admission, item number 2.
Anyone for the petitioner?
My lord, I am appearing in item number 2.
Okay. Criminal revision.
Yes. I have to submit a case diary in this matter, my lord. I believe that my it is already furnished, my lord.
Yes, it's here. Okay, yes. But the other side?
My lord, if it may be pass over for the time being, I believe that
Okay,
they are on the way.
maybe they are in code number 1. Pass over for
Yes,
time being.
maybe.
Item number 3.
My Lord, I'm for the petitioner.
Okay.
The learned counsel for the respondent, my Lord, she was here and stated that she has received instruction from the
Instruction.
concerned respondents.
Respondent 11, I think.
Yes, my Lord.
Yes.
However, she has not filed any
Not yet
affidavit.
filed.
So she may be granted a few weeks' time to file affidavit,
Okay.
enclosing all the
Steps taken.
award and approval of the award and necessary documents.
Yes. Heard learned counsel for the petitioner, Shri L.H. Lian Rima, Senior Advocate, assisted by
Ruth Lal,
Ruth, yeah,
Roth Valley.
you got the name, no? It is the learned counsel for the respondent is not present when the matter is called. However, learned counsel for the petitioner has stated that he has been informed that instructions have been received by the counsel for respondent number 11. Accordingly, list the matter after 2 weeks, and in the meantime, the respondent number 11 shall file his show cause reply explaining all the steps which have been taken till date.
Obliged.
List the matter after 2 weeks.
Item number 4.
Please, Your Lordship.
Yes.
Yeah.
Here also,
My lord,
yes.
in the after implementation of the newly chief secretary, Sri Kili
I
Raman,
believe the new chief secretary matter.
yes,
Yes, you have impleted.
yes, I have implemented in interlocutory application number 194 of 2024.
And
The
steps.
same was allowed. And in the last court date, my lord, on 14th February 2025,
Yes.
notice was issued in respect of the newly implemented respondent number 6 with ID card. The same was returned on 18th March 2025. However, till date,
None
have not
appears.
filed any affidavit.
Respondent 11 also does not appear. Huh? No. Newly impleted respondent is 6. Respondent
Newly
number
impleted
6.
is 6, my lords.
And you have amended the cause title also.
Yes, my lord.
It is stated by the learned counsel for the petitioner that the new chief secretary has been impleted as respondent number 6 in the present petition, and accordingly the cause title has been amended. And is anybody appearing for you're appearing, Mary? You
Yes, my lord, I'm appearing for the respondents, but not the newly impleted.
okay.
I do not have instructions to appear on behalf of the newly impleted yet.
Not for the newly impleted respondent.
Yes. I
Okay. It appears that a notice is complete on the newly impleted respondent number 6. However, none appears when the matter is called. Learned Counsel Mary Kangti submits that she appears for the other respondents, but no instruction has been received till date for the respondent number 6. Accordingly, list the matter after 2 weeks, awaiting appearance of respondent number 6.
Item number 5.
Obliged, my lord.
Please, Your Lordship, my Lord. This is an MAC appeal filed under 173, Section 173 of the MV Act 1988, my Lord, whereby the instant appellant is challenging the judgment and order dated 24/1/2024 in MSCT case 16 of 2020, along with the impugned corrigendum dated 11/6/2024 to the said judgment and order dated 24/1/2024 in MSCT case number 16 of 2020, passed by the learned presiding officer, MSCT Aizawl, Mizoram, my Lord. My Lord, on the last occasion, my Lord, I believe the notice was issued to respondent number 1 and 2, my Lord.
Yes.
However, my Lord, it has been
The AD card has
answered,
not
my Lord.
returned.
My Lord,
Notice not returned from respondent 1 and 2 till date.
till date, my Lord.
Yes. Okay, we'll give them some time then. Office note dated 27/3/2025 indicates that the AD card / service report has not returned back from respondent number 1 and 2 till date. Accordingly, list the matter after 3 weeks, awaiting the service report on respondent number 1 and 2.
Obliged, ma'am.
Item number 6.
Your Lordship,
Yes.
yes, as per the last court's order, we have served a copy of notice to the respondent number 1. And
Okay.
we also have filed an affidavit indicating service of notice.
You have filed the affidavit.
Yes, Your Lordship. Indicating service of notice upon the respondent number 1.
Affidavit of Dusty. Okay. None appears, no?
No.
You have filed it on 12/3.
12/3, Your Lordship, yes.
2025. In the present application, the revisionist / petitioner has taken steps for notice on the how many respondents?
5 respondents, but Dusty Mode, we have sent it
Dusty for
respondent number 1.
1 has taken steps for notice on respondent number 1 by Dusty Moat and has filed an affidavit to that effect on 12/3/2025. However, when the matter is called today, None appears for the respondent number 1. What about the state respondents? They are represented?
They are, yes, Lordship.
Okay. 2 to 5, all state respondents. Who appears for 2 to 5? Anyway. Oh, okay. It is stated that respondent number 2 to 5 are being represented by the Learned Advocate General. Accordingly,
Also, if your Lordship may call for the LCR.
yes, we will do that.
But my lord, if I may be allowed to intervene, it's not my case, but this matter is taken up by my learned friend Vani, and she's in court number 1, my lord, on Lakes, my lord, not the AG.
Oh, not AG. Okay,
Yes.
then delete that
My
part.
learned
Huh?
friend Vani, Vani Siami.
The respondents number 2 to 7, 2 to 5 are represented by government advocate. However, the said government advocate is on legs in court number 1. The notice on respondent number 1 is deemed to be complete. Accordingly, call for the LCR from the Court of
Civil Judge.
Learned Civil Judge Junior Division 4, Aizawl, in CMA 435/2023 in connection with civil suit number 38/2019. Stop. List this matter after receipt of the LCR.
Obliged, your Lordship.
Item number 7.
May it please your Lordship? Yes, two interlocutory application has been filed, my lord. And one, that is IA 48, is for stay application for stay, and the other one, IA 206, is for condonation of delay of 49 days. And my lord, I regret to inform that I think it was wrongly recorded. For IA 48, it was for application for stay. However, in the order, it was for IA 206.
The case number
Yes,
was wrongly
it was
typed.
Yes. Yes,
So
ma'am.
actually that order should have been 4206.
Yes, my lord.
Yes, I remember. And then the objection was supposed to be filed. You
Yes,
filed.
Lordship. Yes, already filed, Lordship.
So give me 206, IA 206. .48 is stay and 206 is
Condonation.
condemnation. Yes, this is the one where there was delay of 49 days or something.
Yes, your lordship.
Okay, let's hear you on the condonation.
Yes, my
Your-
lordship,
Your para.
this-
Where's your
My grounds for
Yes.
condonation is at page 3.
page 3?
Your Lordship, I know I'm not supposed to go deep on the merits of the case, but for better understanding, if I may enlighten Your Lordship with the brief facts of the case. So, the respondent has filed an eviction suit number 3 of 2023 against me, and in that court order, the impugned order dated 25/7 of 2024, I was directed to vacate the land within 3 months. So, and also execution case has been filed. So, in that execution case, without, only on verbal submission of the respondent, the learned senior civil judge has ordered, give direction to put my building under lock and key. So, I have also already suffered an irreparable loss and injury on that order, and even the execution petition was not served, execution application was not served to me. So that is the brief facts of the case.
So that's
So
why
now-
in the main case you have challenged that.
Yes, yes. So,
So anyway, now you go to the delay. What caused the delay?
yes.
If there's sufficient cause, let's see.
First, the order, the impugned order dated 25/7/2024 was informed to me by my previous counsel on 29 of July 2024. That is after 4 days from the pronouncement of the order. Then, when I approached the previous counsel, I was advised that I have to engage a new lawyer who could file an appeal for me before the High Court. So I find some difficulty in searching for the lawyer, but after 2 weeks, the applicant has approached me. That is on 29 September of 2024. So before this applicant has approached me,
29 September or August? 29/8.
August 29/8, 2024. So while the applicant was searching for an appropriate lawyer, a certified true copy was applied for. A certified true copy of the impugned order was applied. And my lord, if I could take you to page 10, that is Annexure 1.
Page 10.
Yes. On the top part, you could see that the date of application for the copy. It is on 14/8/2024. Yes. And in the last column, there is a date of making over the copy to the applicant. That is on 20th/9/2024. Even though this was all during the limitation period, this took around 38 days. So after the applicant has all the necessary documents.
You applied on 14/8/24 and you got a copy only on 29/24.
Yes. So it took 38 days. And after the applicant has received all the necessary documents, she has approached me on 29 of August 2024. Then I started studying the cases, but just before I could finalize the appeal, I have found that her name, Arlil Thanpari, was recorded in the order as only Thanpari. Her initial R and Lal was not recorded. And if I take my lordship to page 15, I have annexed her Aadhaar card. So in that also it has recorded that her true and correct name is Arlil Thanpari.
Page
19, my lord.
19.
Annexure 2.
Okay.
So I have filed CMA number 978 of 2024 before the learned senior civil judge. Order was passed. Notice were also served to the parties, but the learned senior civil judge invites submission for written objection and fixed a date on 2nd of December 2024. Here, my lord, the last date of filing this appeal was on 23rd of October 2024, and the limitation period has already lapsed during this time. So,
CMA was filed for correction of the name.
yes, my lord. It was filed on 1st of November 2024.
Then when was it allowed?
Till now, my lord, this CMA is not disposed yet.
Oh, sure.
So when order was issued by the learned senior civil judge, he invited submission for written objection for the opposite
From
party,
the
the
other side.
respondent herein, on 2nd of December 2024. So when on 2nd of December last year, the opposite party was absent. So she was given another chance to submit her written objection that was on 30th of January 2025. So
Then finally it was filed on
it was filed on
12th
12th
December.
of December in order to any further in order to
Okay. Yes.
in order to avoid any further delay. So my lord,
Yes.
I apologize. The order sheet could not be annexed. The CMA order sheet could not be annexed at the time of filing of the appeal. But on the same date of filing of appeal, the certified copy is issued to me.
And this is still not disposed.
Yes, yes, my lord. So that is my grounds of appeal, and my grounds taken for appeal are also good grounds. So I humbly pray that your lordship may condone the delay of 49 days in filing the appeal.
Yes.
Yes, Lordship. Although it is 49 days, as you well know that Lordship, in order to condone the delays, there must be reasonable and sufficient cause. Here, in the instant, Lordship, the applicant main grounds for condoning the delay days is not acceptable because it is proof that Lordship, the applicant has made false statement in order to get their delays days are condoned, Lordship.
How false statement?
Lordship, if we look at Lordship, if I may take your Lordship to page number 5 of the condonation application, Lordship, page number 5. Yes, Roman number 8, Lordship. May I read, Lordship? That after obtaining a certified copy of the impugned order dated 25/7/2024, the applicant has found out that her name has been recorded as Thanpari, whereas her true and correct name is Lal Thanpari, Lordship. From this point, it is clear that the applicant had stated that after obtaining certified true copy, they only found out that her name is recorded as Thanpari, whereas her true correct name is Lal Thanpari. Lordship, if I may take again your Lordship to my affidavit in opposition, page number 8, Lordship. Yes, that is the acknowledgement receipt and the type copy is at the next page, Lordship, page number 8.
Annexure 1.
Yes, Lordship, Annexure 1. May I read, Lordship?
Yes.
Receive a copy of eviction suit number 3 of 2023 along with order dated 26/4/2023 passed by Senior Civil Judge 2 in eviction suit number of 3 of 2023, and at the bottom, Lordship, the applicant wrote her name as Thanpari and appended her signature on 10th of May 2023. From this acknowledgement receipt, Lordship, it is clear that the applicant had actually figured out that her name has been recorded as Thanpari on 10 May of 2023 and not at this belated stage, which is after 29/2024. That dated 29/2024 is, Lordship, the applicant was the date which applicant was furnished a certified copy.
This receipt, Annexure 1, is dated 10th May.
Yes, 10 May 2023, Lordship. On that day, the applicant already had figured out that her name has been recorded as Thanpari. That is before the commencement of the trial, actually before the commencement of the trial in that land trial court, Lordship. And during the whole proceedings of the trial,
but she uses her name as Lal Thanpari also. Sometimes it happens, no?
Yes, Your Lordship.
Isn't it?
I would like to
Short
address
form.
on that point. And this receipt annexed by my learned friend, it is neither a court order nor a summons
Lordship.
from the court. So
as per
this
our
receipt
plain,
is baseless.
the applicant already known that her name is recorded as Thanpari. So their plea of at this belated stage is not acceptable, Lordship, because it is very clear according to her acknowledgement receipt, Lordship. And Lordship, if we come again to page number 5 of the condonation application, Lordship.
Page 5.
Yes, page number 5 of the condonation application, Lordship. That Roman number 9 and 10. In Roman number 9, Lordship, the applicant stated that she submitted application for correction of her name on dated 1st of November 2024, Lordship.
Yes.
After finding out that, Lordship, the applicant had figure out her name as recorded as third party on 10 of May 2023. Their plea of application for correction of her name, which is submitted only on 1st of November 2024, is also, Lordship. It only appears that these are also an attempt to escape the bar of limitation, Lordship, nothing else. So it is clear that because of this alleged incorrect name, Lordship, the applicant had stated that this has caused considerable delays in filing their petition, Lordship. But as I have already mentioned many times, Lordship, the applicant had already figured out that her name has been recorded as third party on 10 of May 2023. And during the whole proceedings of the trial, Lordship, they doesn't have any query about her name. So at this belated stage, raising of such question is, Lordship, it is only an attempt to escape the bar of limitation. So it is clear that they doesn't have any reasonable cause to condone their application, Lordship. And Lordship, if I may take you again into page number 4 of the condemnation application, page number 4, Roman number 7, Lordship. May I read?
Yes.
That on dated 29/20/24, the applicant was furnished a copy of the certified true copy of the impugned order, dated 25/7/2024, and a copy of plain and written statement with annexure, that the time taken for obtaining certified impugned order is about 38 days. In this point, Lordship, they have clearly stated that on dated 29/20/24, they have received a certified copy.
Yes.
And in Roman number 9 of their application, Lordship, which is page number 5, Lordship, they stated that application for correction of her name was submitted to the Land Trial Court on dated 1 of November 2024, Lordship. So from this point also, Lordship, it appears that between this day, there is about 33 days, Lordship. Why during this period, why they doesn't submit that application is also not explained by my learned friend, Lordship.
You mean between the obtaining of the certified copy and
Yes.
the filing of the CMA?
Yes, between that day, Lordship, there is 33 days, Lordship. Yes, they doesn't make any explanation between these days.
So that will be about 33 days.
Yes, Lordship. These 33 days shows their utter negligence in pursuing their case, Lordship. So their plea is not a cogent reason to condone the delay, Lordship.
Okay. Anything else?
Yes, Lordship, only one last thing.
Yes.
As my learned friend had mentioned that CMA
CMA 978.
yes, Lordship, CMA 978 of 2024 was submitted to the Land Trial Court for correction of her name. And as the Land Trial Court has not disposed of that CMA, it appears that the applicant Arlal Thanpari is not a party in the case, Lordship, as the trial court has not disposed any order with regard to their application. So from this ground also, it appears that the applicant doesn't have any right to make the instant IA, Lordship. Lordship,
Yes.
yes, and I have one case which is Lal Nun Moya versus H. Sai Ching and 6 other. uh, that is a
This
case,
is regarding delay.
yes, an application for seeking continuation of 64 days. Lordship, in that case, Lordship, the appellant doesn't have any reasonable and sufficient cause. This coordinate bench has rejected their application, even though it is only 64 days, Lordship. Here in the instant case also, even though it is 49 days, they have to meet reasonable and sufficient cause. But those kind of reasonable and sufficient cause is not provided by the applicant, so Lordship, it is liable to dismiss their application. That is my humble submission, Lordship.
So what do you say about this 33 days in between 25/7/24 and 1/11/24? You have
Yes,
not
my lord.
stated anything in your...
Regarding that, in my application, I have stated that when the documents were ready, at page 4, Roman number 5, I have written that the present council took immediate steps in studying the case and collecting necessary documents. So when the applicant has approached me on 29th August 2024, I have started studying the case, and even though I'm not supposed to go to the main appeal, in our written statement, the previous council has written her name as Arlel Thanpari. So I find that the names were used interchangeably, like Lal sometimes they use Thanpari, sometimes they use Lal Thanpari, sometimes they use Arlel Thanpari. So during that time, I called my client again, and she said, in my Aadhaar card, it is recorded as Arlel Thanpari. So because of that, the CMA could be filed only after the limitation period has lapsed. And also, my lord, regarding the receipt, my learned friend has
sometimes
contradicted.
she uses Lal Thanpari, sometimes she uses
Thanpari
Thanpari,
and
sometimes
Arlel Thanpari.
Lal Thanpari.
Yes, your lordship. And regarding the receipt annexed by my learned friend in his affidavit in opposition, he has made a contradictory statement that this present applicant has received the copy of eviction suit. So my learned friend cannot take the point that she is not the party in this appeal.
Yeah, that
Yes.
is, of course.
And also, your lordship, I have relied on two judgments passed by the Supreme Court. One is 2005, 3 SCC 752. State of Nagaland versus Lipokau and others. Your lordship, the brief facts of the case is mentioned in para 2 and 3. If I may read out the relevant portion, that is in para 15,
Wait.
page 760.
760.
Yes.
I think you have given me the wrong citation. State of Nagaland versus Lipok, that one is not here. Just give me the citation again.
2005,
2005,
3 SCC
3 SCC
752.
752.
2.
Yes.
Yes. Para 15, from the 8th line.
15.
Yes,
Yes,
Your Lordship.
yes.
Para number 15, from the 8th line, the expression sufficient cause should therefore be considered with pragmatism in a justice-oriented approach, rather than the technical detection of sufficient cause for explaining every day's delay.
This case, of course, pertains to government
Yes,
departments.
yes, but
Yes,
if Your
Lordship.
Lordship could apply,
It is correct. State and individual cannot be put in the same footing, Lordship. As I have, that the ruling I have submitted in point number 9 also, it is clearly mentioned, Lordship. Page number 6, para number 9. Yes, may I read, Lordship?
Para 5.
No, para number 9,
Para
Lordship.
9.
Yes. Yes. May I read, Lordship?
Yes.
It may be further seen that although the order sought to be impugned was passed by the court below on dated 27/9/2023, the applicant applied for a certified copy of the same only on 18/1/2024 after the expiry of the period of limitation for filing of the appeal. Similarly, a certified copy, Lordship, the important para is, similarly, a certified copy of the order dated 23/8/2018 passed in CMA number 221 of 2018 was again applied on 21/2/2024 only, and which again was issued on the same day itself. The important line is this, Lordship. Reliance has been placed upon the case of State of Nagaland versus Lipok Au and others, passed by the Apex Court. However, on perusal of the same, it is seen that the Apex Court in the given facts of the case was of the view that the state cannot be put on the same footing as an individual in view of the fact that an individual will always be quick in taking the decision whether he pursue the remedy by way of law, of an appeal or application. So, Lordship, state and an individual cannot be put in the same footing. So their ruling is also not applicable in this case.
and another judgment I have relied on is Your Lordship. Citation 1998-7 SCC 123 in Balakrishnan versus M. Krishnamurthy. Yes, Your Lordship. The relevant portion is at paragraph number 11. If I may read with your Lordship permission. Rules of limitation are not meant to destroy the rights of the parties. They are meant to see that parties do not resort to dilatory tactics but seek their remedy promptly. And the next relevant portion is at para 13. If I may read out with your Lordship's permission. It must be remembered that in every case of delay, there can be some lapse on part of the litigant concerned. That alone is not enough to turn down his plea and to shut the door against him. And also, just my last submission, Your Lordship, if I may. Even though I'm not supposed to go into the merit, I have this one Supreme Court judgment in the case of Inder Singh versus State of MP 2025, SCC online SC 600. The relevant portion is at para 14, my Lord. If I may read out with Your Lordship's permission. Yes. There can be no quarrel on the settled principle of law that delay cannot be condoned without sufficient cause. But a major aspect which has to be kept in mind is that if in a particular case the merits have to be examined, it should not be scuttled merely on the basis of limitation. So, Your Lordship, my Lord, in this case, the applicant has been deprived of her right to run her business within her land. And also, this eviction suit was passed merely on the basis of a spot verification report done by an appointed surveyor. This surveyor was not cross-examined or given a chance to be examined. And the parties were also not given chance to adduce their evidence. So, Your Lordship, if you could kindly consider all my submission, there were no negligence on part of the applicant, and if this delay of 49 days is not condoned, then the applicant will suffer irreparable loss and shall suffer severe hardship. So it is my humble prayer that this delay of 49 days may be condoned.
Okay, right. This application under Section 5 of the Limitation Act 1963, read with Order 41, Rule 3A CPC, has been filed by the applicant, praying for condonation of delay of 49 days in filing the connected appeal against the impugned order dated 25/7/2024, passed by the Learned Civil Judge, Senior Division 2, Aizawl, in eviction suit number 3 of 2023. Stop. Next para. Learned Counsel, MS
H. Lalrausangi.
H. Lalrausangi, appearing for the applicant, has stated that the applicant first came to know about the impugned order dated 25/7/2024 after the same was furnished to the applicant by her previous counsel on 29/7/2024. Thereafter, the applicant approached her previous counsel on 12/8/24 and urged them to give her advice regarding the said order. Stop. Thereafter, the applicant was informed by her counsel that if she is aggrieved by the impugned order of 25/7/2024, she would have to file an appeal before the High Court. Stop. The applicant, being aggrieved by the said impugned order dated 25/7/24, approached some lawyers who could make the appeal on her behalf. The applicant took about 2 weeks in search of a lawyer who would be willing to handle her case. Stop. The applicant was able to engage the present counsel on 29/8/2024 to take necessary actions in filing an appeal. Stop. The applicant, through her previous counsel, had submitted an application on 14/8/2024 for a certified true copy of the impugned order dated 25/7/2024, which was supplied to her only on 25/7/2024. You correct me on the dates, okay, if I go wrong.
Yes, sir.
Stop. Thereafter, the present counsel took immediate steps in preparing for the case and collecting necessary documents. Stop. However, the present counsel, upon going through the records, has found out that the name of the applicant has been recorded as Than Pari in the case records before the Learned Trial Court, whereas her true and correct name according to her Aadhaar card is R. Lal Than Pari. Stop. Thereafter, the applicant has filed CMA 978 of 2024 before the Learned Trial Court for correction of her name on 1/11/2024. Stop. the Learned Trial Court was pleased to issue notice on 1/11/2024 calling for objections, if any. Stop. That in this CMA, the opposite party failed to appear on 2/12/2024, and thereafter summon was issued for submission of the same on 31/2025. Stop. However, even if the CMA had not been disposed, the present council, in order to avoid further delay, has prepared and finalized the present application along with the connected RFA, and finally the application has been filed on 12 December 2024, whereby a delay of 49 days has been caused in filing the present appeal. Stop. It is therefore prayed that the delay in filing the delay of 49 days in filing the connected appeal against the impugned order dated 25/7/2024 may be condoned, as it was due to bona fide reasons and circumstances beyond the control of the applicant. Stop. Next paragraph. Learned Counsel, Shri,
K. Kam Thian Manga.
your name is reflected here.
Yes, Lordship. K. Kam Thian Manga.
Kam Thiang Manga, yeah, appears for the respondent and has filed his affidavit in opposition. Stop. In the affidavit in opposition, the Learned Counsel has stated that no sufficient cause has been made out by the applicant for condoning the delay. Stop. It is stated that the applicant's name was addressed as Srimati Thanpari, and when the eviction suit number 3 of 2023 was filed before the Learned Trial Court, the said copy was put forth by the applicant at this belated stage, which is actually after 2 months from disposal of the case, is baseless, false, and not acceptable. Stop. And it only appears to be an attempt to escape the bar of limitation, and therefore the instant application is liable to be dismissed. Stop. Learned Counsel also states that a copy of a certified true copy of the impugned judgment was supplied to the applicant on 29/2024, according to the records. Stop. And the CMA for rectification of the name was filed only on 1/11/2024. Thereby, there is a period of 33 days.
Lordship, it is 41 days.
41 days,
Yes,
huh?
yes.
In between this 29. No, wait.
That 33
Certified
days.
true copy was obtained on 29.
Yes, 2024.
2024, and CMA was filed on 1/11.
Yes.
So
between.
that is
41
days.
days.
Okay. So Learned Counsel for the applicant states that in between 29/2024 and 1/11/2024, there is a period of 41 days which has not been explained in the application, and no cause has been shown regarding the reasons for delay for this 41 days. Stop. That the Learned Counsel also states that the applicant has failed to explain as to how many days was taken for preparing the instant application and the date of finalizing the application. Stop. Accordingly, Learned Counsel submits that the delay of 49 days is due to deliberate negligence on the part of the applicant, and the same is liable to be dismissed. Learned Counsel has referred to the case of Lalnunmawia versus H. Sachinga and 6 others. You see later, okay, from this. Versus H. Sachinga and others in IA Civil 45 of 2024, wherein a coordinate bench of this court has rejected an application for condemnation of delay of 69 days.
64 days, Lordship.
64 days. In the aforementioned case, the court had stated that the applicant had applied for a certified true copy of the impugned judgment only after the expiry of the period of limitation, and has also observed that an individual cannot be equated with the state, as an individual will always be quick in taking a decision whether he will pursue the remedy by way of an appeal or application, whereas the state is an impersonal machinery working through its officers or servants, and therefore some consideration is given for this reason. Stop. However, the applicant in that case was not a state but an individual, and therefore the application for condemnation was rejected. Stop. Oh, sorry, I didn't. While coming to the applicant's submissions, you just give these rulings also, in the first para, where the submissions of the applicant are there. Learned Counsel, just put a separate para, new para. Learned Counsel for the applicant has relied on the case of N. Balakrishnan versus M. Krishnamurti, reported in 1998, 7 SEC 123 at paragraphs 11 and 13, to support her contention that the rules of limitation are not meant to destroy the rights of parties, but they are meant to see that parties do not resort to dilatory tactics but seek their remedy promptly. The Honorable Supreme Court in this case had observed that in every case of delay, there can be some lapse on the part of the litigant concerned. Stop. That alone is not enough to turn down his plea and to shut the door against him. Stop. Learned Counsel has also relied on the case of, no, I will not refer to this because this is state, no? Which was the other one?
Inder Singh.
Inder Singh has also relied on the case of Inder Singh versus State of Madhya Pradesh, reported in 2025 SCC Online SC 600 at paragraph 14. Stop. In paragraph 14 of the above cited case, the Honorable Supreme Court has stated that you quote this para 14, okay? There can be no quarrel such and such till on the basis of limitation, the entire para 14. Relying on this judgment, the Learned Counsel states that delay cannot be condoned without sufficient cause, but the merits of the case also has to be examined, and the application for limitation should be examined along with the merits of the main case. Yeah. So now you come to next para, observations. This court has examined the contentions of the opposing parties and considered the grounds set forth by the applicant in the application. The court has also considered the issue of the wrong name being recorded before the trial court records, and is of the view that such type of mistakes is very common, as the name, and especially in the present case, as the name of the applicant is used as Thanpari or Lal Thanpari or R. Lal Thanpari. Stop. In such a situation, the submission of the Learned Counsel for the applicant that the wrong entry of her name was discovered only later can be a valid ground. Stop. It is also seen that sufficient cause has been shown in order to condone the delay of 49 days in the present application. Accordingly, the delay of 49 days is condoned and the application is allowed.
Deeply obliged, Your Lordship. And Your Lordship, for IA number 48, that is application for stay of the impugned order dated 25/7/2024 and its consequential order in execution case.
Lordship, with regard to that IA, we have received their application only on yesterday at around 5 p.m. So we doesn't have any proper time for making objections. So if the same can be taken up after a week, not this day, Lordship.
And Your
Okay,
Lordship,
1 week should not
Okay.
make
Yes,
much
Lordship.
difference.
yes, Your Lordship, and one more prayer. At page 15 of my stay application, I have prayed for interim. Yes, Your Lordship, in this case, in execution case, Only on the verbal submission of the respondent, the learned senior civil judge has directed to keep my building under lock and key. So that building is my main source of income, and I am deprived of my right under Article 21 of the Indian Constitution.
Okay, add interim
So-
stay and then we consider the stay application after 1 week. Okay. We'll add interim stay till for 1 week.
Lordship,
Mm.
the house
Yes,
is,
yes,
as my learned friend
Because
mentioned that
if she is to be evicted, then irreparable loss will be
Yes.
caused.
Yes, Your
So
Lordship.
that is
that is
There
not,
can be no
some
objection.
interim
that is
protection.
not their main building,
Some-
Lordship.
Some interim protection is required, isn't it? This is 48, okay, IA 48. This is an application under Order 41, Rule 5 CPC.
Lordship, please,
Yes.
only one last thing.
Yes, yes.
As my learned friend mentioned that the house is under lock and key, so no more action is available to take from both the parties. So if it is
Status quo, status quo.
yes, status quo,
Yes.
Lordship.
No, Your Lordship,
so
for
to-
stay, I am praying for stay of the
It
order.
has to be stated.
and it's
If it is status quo,
No,
Lordship,
Your Lordship,
it would
as
be
I
fair.
have
It would be
no.
fair for both the parties,
No, that's what I'm
Lordship.
saying, status quo.
As I have
So it will
submitted,
be as it is, okay. And this
Okay.
is an
Lordship.
application, yes, under Order 41, Rule 5 CPC, for stay of the impugned order dated 25/7/2024, passed by the learned civil judge, Senior Division 2, Aizawl, in eviction suit number 3 of 2023, and the consequential order dated 30/1/2025, passed in execution case number 171/2024, in eviction suit 3 of 2024. Stop. Learned counsel for the respondent has submitted that he has received a copy of the application only yesterday,
Yes,
and
Lordship.
therefore prays for some time to file his counter affidavit. Stop. The prayers allowed, list the matter after
2 weeks, Lordship.
after 2 weeks. Stop. In the meantime, status quo as and today be maintained with regard to the order dated 25/7/2024 in eviction suit 3 of 23, and the order dated 30/1/2025, passed in execution case 171/2024 till the next returnable date.
Pledge, Lordship.
Item number 8.
May I please, Your Lordship? My Lord, in the last court order, notice was not completed only upon respondent number 3. That is the owner.
Owner of the vehicle.
Yes, my Lord.
Should we wait or you take first steps?
Lordship, I would like to have one submission. The owner of the vehicle does not contest on the tribunal also.
Did,
So-
did not contest.
Yes, my Lord. So I think he do not have any interest in this case or not.
Acha, acha.
He did not contest at the tribunal.
17/2/2025. And the other respondents are appearing.
Yes, my Lord.
Today they are absent.
Yes.
Office note dated 27/3/2025 indicates that the service report on respondent number 3 has not returned back till date. Respondent number 1 and 2 are already represented.
Yes, my Lord.
Stop. Learned counsel for the appellant states that the respondent number 3/owner of the vehicle did not contest the application even before the trial court.
Yes, my Lord.
Stop. Accordingly, the matter may proceed.
Your Lordship,
Yes.
one submission. If I may be allowed to have a paper book may be required in this matter.
I think LCR has also not come, isn't it? We have not called for the LCR also.
Lordship,
LCR is there, okay.
yes.
Stop. The LCR has been received. The registry is directed to prepare paper book as per procedure, and the matter may be listed after receipt of the paper book by the parties.
Yes, my lord. Oblige.
Item number 9.
My lord, this is bail application and it has been listed for the first time.
So,
If notice may be
notice
issued.
accepted. or-
Yes, the learned special PP is here
Okay.
for the NCB.
Okay. You have to obtain some records.
I have to obtain instruction for
Instruction.
filing written objection, Your Lordship.
Mm.
And for that, 2 weeks' time may kindly be
2
granted.
weeks.
My lord, if 2 weeks is granted, then the court will be on a holiday, considering the ensuing holiday, court vacation.
Yes, yes.
So,
Holiday starts
It's
from
an urgent
14th.
matter, so if 1 week may be given.
1 week. You take 1 week. Office is here, isn't it?
No, my lord. They are
Mm.
down there in Guwahati, my lord.
And however, you,
There is no
No, but-
establishment of NCB.
But scan
here.
copies can
Yes,
be
my lord.
sent these days. You ask for
Yes,
scan
that can
copies
be
and
done,
then
but now,
1
Lordship,
week. Mm.
Yes, I will have to
Yes.
send the scanned copy of the petition, number 1. And then they will circulate within their organization.
Mm.
And the one who is the officer responsible for this case will handle and will be endorsed to certain officer, and that will take time, my lord, actually. So, and now even after they send up the instruction to me, I will have to file affidavit, my lord. For that, I have to prepare and need some time. That's the
So 1 week from today is 4th April. So if we say 2 weeks, then we can put it on 11th April also.
Then I think, my lord,
10th, 11th.
we can have a fixed date, my lord.
That's why
Okay, we can have it on 9th, my lord.
9th April.
9th April.
Mhm.
That is still not a
Yes.
holiday.
Okay.
11 also, my lord.
Heard learned counsel for the petitioner as applicant, and also learned counsel appearing for the respondent. What is this? DRI or
NCB.
NCB, Lordship.
NCB?
Narcotic
Respondent
Control Bureau.
NCB. Learned special PP for NCB has prayed for some time to obtain instructions and to file his objections. Prayers allowed. List the matter on 9th April 2025.
Oblige.
Oblige, Your Lordship.
Item number 10.
This is in that other limitation.
May it please, my lord. This is a state appeal, my lord. And in terms of the order dated 6/2/2025, my lord, at paragraph number 2, we were permitted to take service of notice upon the respondents by way of dusty, my lord.
Dusty, yes.
We have been able to serve 34 out of the 36 respondents, my lord.
Okay.
So if your lordship can grant us another 2 weeks' time to complete the dusty and to file the affidavit, completion affidavit accordingly, my lord.
So how many are left now?
Only 2, my lord, because
Only
they
2.
could not locate their location anymore, my lord.
Okay.
Altogether, there are 36 respondents. 34 have been served a copy.
Okay.
2 remains, my lord.
You are a government advocate?
Additional Advocate General, my
Okay.
lord.
Learned advocate, additional advocate general appearing for the appellant has stated that dusty service has been made on for 34 respondents. However, there are 2 more respondents to be served notice upon. Stop. Accordingly, he prays for some time to complete the service of notice. Prayers allowed. List the matter after
2 weeks.
2 weeks.
Oblige, my lord.
Oh, yes. Okay. That Zima, I think this is the Zima.
May I please, Your Lordship, yes. By filing this revision petition, We are challenging the order of the Landed Special Court,
Yes.
NGNPS, rejecting the application for release of my vehicle, my lord. Lord, actually this
Mary,
is...
you have received the case diary and all?
Yes, Your Lordship, I have a copy with me in hand.
Okay. Oh, yeah, it's here. Are you the owner, registered
Yes,
owner?
I am the owner, my lord, registered owner. And my lord, this case is covered by the order dated 6/9/2023 of the Coordinate Bench of this Honorable Court in Criminal Revision Petition number 10 of 2023, which I have annexed at page 24, my lord, Annex 3.
Page 24.
24. This is similar with the present case, my lord. The owner,
No,
who
wait,
was not
wait,
implicated in the case, has applied for release of his vehicle, and the Landed Special Court rejected the application on the ground that the case was at a stage of investigation. However, we approached, he approached this Honorable Court by filing the criminal revision petition, and the order of the Landed Special Court was set aside. And the direction for release of the vehicle was made by this
No,
Honorable
the
Court.
law on Zima is very clear. If registered owner comes before the court, then usually the court will give. But then we have to ascertain the ownership first, and then the accused should have said that, you know, you are the owner, and that you have nothing to do with the seizure, with the contraband. So any statement of the accused
My lord,
to that effect?
There was no statement, but my lord, they are registered.
Where is your RC? Have you enclosed?
Page 22, my lord.
Page 22.
Annex 1 is the smart card, the registration certificate.
Not very clear, but anyway. Page 22.
The name of the registered owner was at the fourth line of the
Lal Nun Nema.
Lal Nun Nema, yes, Your Lordship.
Lal Nun Nema. Okay. And where have you stated that you do not know anything about the substance being carried? Have you stated in your pleadings?
My lord, we have stated before the Landed Special Court as well.
Mary, what about the case diary, the statements of the accused? What has the accused said about the vehicle?
My lord, they did. My lord, I'm sorry. I have gone through the statements. It's in vernacular language, but then no indictment of the present applicant is stated in the statement of the accused.
Okay.
And Your Lordship, to cut the matter short,
Yes.
I have spoken with the case IO yesterday, and they told me that they do not have any objection
Yes.
if
Yes.
if the vehicle is released.
Yes. Normally, if registered owner comes before the court, we usually give, unless the accused says that, you know, the owner also
Yes.
was in the knowledge.
Yes. As of now, we cannot say for sure whether they have any involvement or not, because the case is ongoing. The investigation
Ongoing
is
investigation.
ongoing.
When
But
was
then
it
as of
seized?
now, they do not have any indictment against him.
When was the vehicle seized?
16.
The vehicle was seized on 16/2/2025.
16 to 2025. Okay, right.
And my lord, paragraph
yes.
4 of my petition, I have stated that I have no involvement in the criminal case.
Paragraph 4.
Yes, Your Lordship. And we have appraised the Honorable, the learned special court, my lord.
Yes, yes, it's okay. PP is also not objecting, so.
My lord.
This revision petition under section 438 read with section 442 of the BNSS is filed for setting aside of the order dated 27/2/2025 passed by the learned Judge Special Court NDNPS Act Aizol in criminal misapplication 13 of 2025 in excise and narcotic case number N-28 of 2025 under section 21B of the NDNPS Act 1985, thereby rejecting the Zima application of the present applicant, petitioner revisionist. Stop. The contention of the learned counsel for the petitioner, Sri Samuel.
That's only an account time, my lord.
Okay, just write his name. Is that he is the owner of the seized vehicle, Grand I-10 Asta, grey color, bearing registration number MZ-01-P-1388, which was seized by the narcotic police personnel on 16/2/2025 in connection with excise and narcotics case number N-28/2025. It is stated that the seized vehicle is being kept in the excise custody without maintenance, and thereby irreparable damage will be caused to the said vehicle if it is kept in the open in such a manner. Stop. It is also submitted by the petitioner that he has no involvement in the criminal case, and he has also not been implicated in the case by the accused, and he undertakes that if the vehicle is released on Zima, he would produce the same as and when directed by the Honorable Court. Stop. The petitioner has enclosed a copy of, has annexed a copy of the registration certificate of the seized vehicle at annexure 1, page 22 of the application, wherein the name of the petitioner is shown as the owner of the seized vehicle. Stop. The petitioner therefore prays that the seized vehicle may be released to him pending investigation and trial, subject to conditions which this court may impose, and also prays that the impugn order dated 27/2/2025 passed by the Special Court NDNPS Act may be quashed and set aside. Stop. Learned additional PP, Ms. Mary Kyangte appears for the respondents, and she has stated that the records and the statements of the accused person do not show the involvement of the present petitioner till date, and the investigation is ongoing. Stop. She has also obtained instructions from the IO of the case, who has stated that he has no objections on the release of the vehicle, provided the conditions are imposed by the court. Stop. Next para. In view of the above facts and circumstances, this court is inclined to allow the present Zimma application with the following conditions. Stop. Number 1. The petitioner shall execute a bond of rupees 20,000. Zimma bond, sir, shall execute a Zimma bond of rupees 20,000 to the satisfaction of the IO of the case. Stop. Number 2, the vehicle shall not be disposed of or transferred or the ownership transferred before the disposal of the present case, before the disposal of the case, just say before the disposal of the case. Stop. Next condition, the petitioner shall not change the appearance or color of the vehicle. Next condition, the petitioner shall produce the vehicle before the IO and the court as and when required during the investigation or the trial of the case. Stop. With the above conditions, the petition is disposed of.
Highly obliged, Your Lordship.
Yeah, obliged.
Hearing. You just pass it over to next week. Just give this to the steno.